Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for clinicians in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. Many of our members are summoned to court to present their evidence and to be cross-examined. This might be at a coroner's inquest or possibly in some kind of criminal court. And many of them find that it's a very foreign thing to them. They don't know what to expect and they feel highly nervous about that, and they often call us for advice. So today's podcast is really about providing you tips for the witness box and also if you're providing an expert opinion. So today I have with me Mr. Sean O'Sullivan, who's the lead partner at Watton & Carney, our panel law firm. Thank you for joining us, Sean.
It's my pleasure, and good morning to everyone.
And we have with us Tim Cookson, who is a retired MPS colleague of mine, but fortunately we still have him for our podcast. So welcome, Tim.
Hi, Sam.
And Dr. Lucy Gibbard, who is one of my colleagues and who's from Taranaki. Hi, Lucy.
Hi, Sam.
So we've got mostly for you, Sean, because you're the expert in the area.
Okay.
So would you mind, Sean, perhaps just explaining what it is to be a witness and the types of witnesses there are?
Okay, so dealing with the types of witness, there are two types of witness. The first is a witness of fact, and as the name would suggest, that's a person who is giving evidence about what happened, the factual background that's relevant to any proceeding, whether it be an inquest or a court proceeding. So they're just there to provide the facts, to provide an honest view of what happened, and they're factual witnesses. The second type of witness is an expert witness, and the expert witness there is there to provide their expert opinion on the relevant issues that may arise in a court proceeding. So they're an expert. Now, it's important to note that a factual witness who's not qualified can't give opinion evidence. Opinion evidence is disqualified. And so you have to be an expert and qualified as an expert to give your opinion as to the facts. All right. And so there are examples of that, I suppose. You want to give, in an operation, the facts will come out, but then an expert would need to give their opinion on whether that was done appropriately or not. So that's kind of the distinction.
So have you got any advice for our listeners around how our members ought to conduct themselves when they're in the witness box? I mean, I've certainly, I know that our members generally are nervous. They want to help often, but they're not quite sure. And often they feel the need to talk as much as they can.
Yeah. Okay. So there are two aspects of this, and it comes back to the point. I think be prepared. Really be prepared. Be across all your notes. Spend a lot of time preparing and making sure that the lawyer who's representing you is explaining everything to you. Normally, you'll be giving your evidence by way of written brief, so you'll simply be reading that out. And your lawyer, if he does ask you questions, will be asking in a very benign and open way, and so you won't have a problem with that aspect of your evidence. You shouldn't. The key is when you're cross-examined, which is the one that puts everyone a bit on edge. And the first thing is to say, well, you're there to assist the court. You're there, so you can. You don't feel too defensive. What I worry about when I'm in court is witnesses who believe every question's a hand grenade. They can ask their name and they go, oh well, why is he asking me my name? You're second guessing what the question is. So you've just got to listen to the question. Make sure you understand it. So the first thing is always be prepared to say, as Tim said, I don't understand the question. Can you ask me to again? Don't guess the question. Secondly, don't in your head go, where's he leading? Where's this leading? Where's this going? Because then you appear defensive. Just simply answer the question and shut up. So don't expand on the question. answer the question as precisely and as quickly as you can, and then be quiet. What a good cross-examiner will sometimes do is not ask you the next question. Like at times in court, you'll just be quiet, and what a lot of witnesses will then do is, I've got to fill that, because good cross-examiners feed off the evidence that's given back. So if you're too expansive with your answers, it just provides more ammunition or more issues for a cross-examiner to feed off. So coming back to summarise that, you're there to help the court. Don't be defensive. 2, make sure you understand the question and be prepared to ask for clarity. And 3rd, just answer the question as concisely as you can, and then be quiet. All right.
Yes, I've been in. I think it was a coroner's inquest or a tribunal. I can't remember now, but I remember when the lawyers are asking the question, and I'm thinking, I have no idea. I'm not in the witness box. I'm just in the gallery supporting a member. And you say, I have no idea why a lawyer should be asking those questions, because medically it makes no sense to me where they're going. But what I tell members now is the lawyer's got a little journey planned and they want to take you down this path, and you don't know where that's going to go, and it might not make sense to you. That's why it's important just to answer a question narrowly as possible, because it's one of those mystery tours.
You're being too kind. Sometimes lawyers have no idea where they're going. I've been in that situation before.
Has that been usual?
Yeah, no, but they do. A lot of lawyers will, and I resist this entirely, is they think, I'm being paid to be here, I better get up and ask some questions. All right. And they simply and they get up and ask questions. And I'm sitting there in court thinking, why are they asking? This is totally irrelevant. But the courts are pretty. When 10 or 15 years ago, you'd get growled at by a judge for doing that. But the courts are pretty lenient now. So there's a lot of stuff that's said, it's asked in court, that I think has absolutely no relevance, or is just filling in time. And that's why it can drive you crazy, thinking, my God, have I missed something? Are they taking me down some line where I haven't seen? And so you just don't go there. Don't be worried if there's questions coming from left field that you have no understanding of, because they're probably just left field.
Okay, that makes me feel more cynical about lawyers than I already am.
Sorry.
Can I just make a little point? A bit earlier, Sean said the lawyer representing you, but actually as a factual witness, you don't have a lawyer representing you, do you?
Sometimes you do, sometimes you don't.
Right.
So if you're a member of MPS and you're being called as a factual member, and we will be standing there and bleeding your evidence, sometimes you'll be called by...
So that's in a tribunal situation,
in an inquest situation,
right?
So we will stand up, we'll call you, we'll introduce you to the court, we'll introduce your qualifications, and we'll take you through your evidence. And we'll ask you questions at the end if we think you do.
Sorry, is that as a witness of fact?
Fact, yes.
I thought you had to be an interested party before you were permitted to have legal representation.
Then what happens then if you're an interested party? Well, even if a party, if you're a factual witness, maybe not be an interested party, then normally in an inquest situation, the counsel who's assisting the coroner will do that.
Oh, okay.
All right.
But in a situation like you're the ED reg and you looked after a stab victim and you're called to court for a criminal matter to provide evidence on the stab wounds.
Yep.
In that situation, you won't have a lawyer representing you. There'll be the Crown prosecutor and a defence lawyer. Is that right?
There'll be in an inquest.
No, I'm talking about in a
criminal
court, because
Crown Counsel.
ED doctors are often
the Crown
actually
Counsel will
called
do it.
for criminal cases.
The Crown Counsel will be your lawyer, in inverted commas, if you like. They will prepare your evidence. At a lower level, it'll be the police, if it's a district court case. The police will prepare your statement, and they'll stand up in court and they'll lead you. All right, they'll introduce. This is Lucy. Blah blah blah. So you should always have someone, whether it be a policeman and a police prosecutor in the district court, or a coroner's counsel in an inquest, if you're just a fact witness, representing you or preparing your evidence and helping you through the process.
So, Sean, can you just talk us through what's the process? So, who who is the person who would be contacting the ED reg, for example?
Okay, we're talking about someone gets assaulted and
they're seen in ED.
Courtney Place, and it's NW. The person who'd be calling would be the police investigator, a detective or a constable at the police force who'd be assigned to the case, and they would be getting a statement off the ED person. All right,
and should the doctor just say, "Oh yeah, I'll give you a statement, no worries," and they get interviewed?
They normally I don't think there's a problem with that. There's not a issue with that. What all I would say is if they are concerned or worried about what they're giving, some of it might be pretty rote and pretty simple,
pretty straightforward,
and nothing. But if they are worried, then they should give you guys a call, and if it's necessary, they can escalate it to us, and we can take them through. And we've done that before, I think, on many occasions. Checked out this police statement, making sure they're not being led. Sometimes the traps are that sometimes police who are very desperate to get a conviction. I'm just putting my cynical lawyer hat on at the moment because I used to act for a lot of defendants. Will push witnesses to out on a bit more of a limb than they should.
Happens a lot, I have to say.
Yeah. And so if you're feeling pressured, and sometimes you may feel pressured, then you don't have no obligation to sign the statement that way. Then just take a breather, send me a draft, and we can have a chat about it and make sure that that you're happy with it. But normally it's fine. But that does happen. So yeah, I mean, and then you should be called. Sometimes that evidence is accepted, and you don't have to give it. Otherwise, you have to turn up and be subject to cross-examination in the way that I've just explained.
And we've also seen examples where the statement that's been basically produced by the police actually differs from the clinical notes in really relevant ways.
Correct.
And so if you don't have someone helping you to make sure that your brief of evidence is entirely consistent with the notes, then that opens obviously a gap.
That's the same with the lawyers often. When your patient's lawyer has asked for a brief of evidence for whatever court case is coming up, I find that often the lawyers are quite leading in the way they put things. So often what I advise our members is, if you would prefer, you should just start it from scratch. And that way you're writing exactly what you believe to be the facts.
I think that as a general rule, it's much better for you to write your own brief of evidence in your words, and I prefer that as an advocate, because I've seen people get into court and they're reading out and they don't understand the words they're reading, and they're huffing going through it. What does this mean? And that it's been written by the lawyer, and it comes across absolutely terribly. Yeah. So to the extent to which you can, it's so much better if you write. What normally I would do is write down what you're saying. So now with transcription and everything, it's really good. So you can just write down, but it's so much more effective and actually believable if it's in your words, not a lawyer or someone else's written.
And obviously MPS will help with that. So quite a lot of our members, if they're writing a police statement, will send it in for us to look at with the notes, and we can just make sure those two things marry up, and it's
And just to follow up on the point that you were talking about, Sean, of appearing dithering and uncertain in court, it is actually really important, whether you're a witness of fact or especially as an expert, to at least have the air of being confident without being cocky, I imagine, so that the court generally can have confidence that what you're saying is a believable thing.
Yep.
So it's not just the facts that you're presenting, but the way that it's presented can be...
But not over cocky.
Yeah.
There's a nice balance to be drawn. You're right. Don't stumble. Have everything now is done on briefs of evidence. It's very, very seldom that you have to give evidence without a written brief. Very seldom. And so if you've read that through, 5 or 6 times, and that's a great start. Sometimes you are asked questions. Sometimes you ask questions by your own lawyer at the end and hopefully you understand where they're coming from, and the lawyer or the advocate, whoever's doing it, has warned you about that. So just make sure you're confident about that, and you're fine.
Can the doctor say no? Let's just say the patient's got to go to court for an employment matter, and the lawyer's contacted you. Is it possible for the doctor to say no?
Yes, initially, but and we'll say an employment case because it's a good example, because it's all a bit a less level below a level, one might say, than say a criminal court, or the lawyer can get a witness summons. So you can be summoned if you're relevant. You can be summoned to give evidence, and if you don't, then there's penalties for not turning up. So the tribunal can make you. The thing is that, and we'll talk tactics here. The difficulty is that a lot of lawyers don't like summonsing. There's two issues that arise out of this. A lot of lawyers don't like summonsing because they get a reluctant and aggro witness that's meant to be on their side, and that becomes a problem. So that therefore takes a little bit of. And there was another thought that came to my head that's completely gone. So if it comes back, I'll come back to it.
You can come back to it.
Yeah.
So look, when you're asked a question by either the lawyer that's representing you or the defence lawyer, are you allowed to refer to your notes? Are you allowed to say, I'm not sure, but can I look at my notes? Is that
Yes,
reasonable?
you are. In fact, you should. Normally, if we talk about patient notes or any notes, they should be in evidence anyway. So what will happen is that all of the relevant documents, in all court cases now, all of the relevant documents are put in what is called an agreed bundle, and they're assigned a number. So you will always have a list or a bundle of documents, we'll call it, on the witness box. And so if you want to refer to them, you can and you should refer to them. That's standard practice.
Are you allowed to take, if you've before got your own copy of the notes and you've annotated it with tabs for which bits where, are you allowed to take your own copy of the notes?
Yes, you are. But I think you would raise that with the person who's presenting your evidence and explain that's what you're doing. And I think they would therefore inform the court. And you should also have a copy available of those for the other parties, because if you've got other little things on them that weren't on that should be disclosed.
Right. Okay.
So that's absolutely fine.
When I did some training on court appearances, it was mentioned that there was an etiquette thing that before if you're wanting to refer to your notes, that you should turn to the judge and say, "Are you happy for me to refer to my notes to answer the question?" Is that still apply as an etiquette thing, or is it fading?
I think just simply saying I'll need to refer to my notes to answer that question properly. That's probably all that's necessary. I think that's fine. I think that would be normal. No one would raise their eyebrows at that.
Shall we think now about being an expert and providing an expert opinion? Tim, what are the things you would like clinicians to know about when they're writing an expert opinion, providing one? We often see that for HDC cases. We often see it for the Health Practitioners Disciplinary Tribunal. They would often have expert witnesses there, and obviously you have it in criminal court, etc. So what sort of things do you think our members should think about?
Well, firstly, they obviously need to be an expert in the area, and we've certainly had cases where we've had expert opinions from people who had never done, for example, the surgical procedure that was in question, and we were able to challenge that in that particular circumstance. So, yes, you need to know what you're talking about. You need to have sufficient time to do it. You need to make sure that you don't have any conflict of interest. So if you're asked to write an expert opinion about your best friend's activities, you clearly are not a suitable person to do that. You need to remember that you're not actually on anyone's side. You're just assessing what had happened and deciding, for example, whether it met the required standards, whether it fitted with guidelines or whatever it might be. Depending on the complexity of the case, you might want to look up evidence, so get your literature search and be quite sure that what you're saying is consistent with international literature, for example. You might need to think about what standard you're applying to your opinion. So is this if everything was perfect, should have been done, or is it what is a reasonable standard in the circumstances? And if it's at the HDC, that's what is actually expected. It's a reasonable standard in those circumstances. So if you have a case where, things might not have gone right, but clearly there were external circumstances that made a significant had a significant impact on that, then that needs to be in your expert opinion as well. And there are probably a whole lot of other things, and I'm sure Sean will help me fill in some of those gaps.
No, Tim, I thought you actually summarised that really well. I think that there are two legs to it. The first is to qualify yourself, and qualifications and experience, I think, are crucial to that. I mean, I was trying to think of an example of an inquest where I had a forensic psychiatrist who'd always been in a private hospital setting, making opinions, very, very, very critical opinions about a person in a community environment. And I thought, we really tested the qualification. That's an example. So it's not just your qualifications; it's a mixture of the qualifications and the experience. And the second thing is that you will always be provided with a. Lucy mentioned this earlier. There's a schedule in the High Court rules which deals with the obligations of an expert, and that's normally used. And the fundamental thing is that you are there to assist the court. You're not there to advocate for any particular party or any particular outcome. So you're completely independent, and that's really important, because when we ask for independent reports, it undermines your credibility of an expert if you come in clearly advocating for one or another outcome or party, and some experts do that because they think they kind of need to do that, and that's wrong. And the third thing is hindsight. It's experts have 20/20 vision because they know the outcome in an inquest situation. The person has died, and a lot of experts I see up front, they go, I realize, of course, that I have the benefit of hindsight and 20/20 vision, and this is different, so I'm very conscious of this. And then they think that gives them a free pass to then do exactly what they've told themselves they shouldn't do. It's okay because and so all I will say to experts is you've got to realize that you've got to put yourself in. It's an incredibly hard thing to do, but you've got to try and put yourself in the position of the person at the time and ignore what has happened later. And I think that's a skill that some have and some don't. I find it unfortunate that it's very difficult for some people to actually ignore the outcome and just give a dispassionate, independent advice on what happened as if it was happening in real time, because it's really hard to do.
I had an example of an expert who gave an opinion about the degree of separation, if you like, from what would have been reasonable practice to what was actually done, but it was fairly minor. And after that opinion went to this was through the HDC, went to the complainant objected violently to this opinion, and the expert then changed their opinion and came up with a much more critical assessment of what the departure was. Any comments on that?
Yeah, no, I mean, if they had provided facts that altered the decision, then then you can sort of go along with it. But if it was just an emotive response that really didn't change the underlying factual basis that had the opinion been based on, then there's just no basis for that. It's just wrong. So yeah, I mean, it's very fine for someone to say, hey, you've got your opinion wrong because you've misinterpreted these facts, or you didn't understand these facts, or you got this fact wrong. That's fine. The factual base is fine. But if it's just an emotive sort of, this is terrible kind of response, then that should be completely ignored.
One comment, I was in a hearing where the expert, the weight of evidence was against the defendant, if you like, in this situation, a tribunal case. And I think that was reasonably clear from the outset. The expert, I think, had relied on the fact that largely everyone believed that the practitioner was probably in the wrong, which I think led to the expert perhaps not doing as thorough a job as they might have done. And they'd also presented an attitude which I would say was not particularly professional. And unfortunately, or fortunately, the slam dunk case was not slam dunk. And it really changed the outcome because of the quality of the expert. And I have no doubt that the expert was an expert in the area, very knowledgeable, all of those things. But because of the conduct and how they approached it, it really did change the outcome of that process. And I think that's quite an important thing for people who do step up to take that role.
Yeah.
That you need to take it seriously, that you should be thorough, well prepared, and come with a professional attitude as well.
Yeah, it's a very responsible role. It's incredibly important. And they have a lot of influence.
Yes.
All right, and that influence, if it's incorrect, is really bad. It can create really bad outcomes.
Yeah, it can. And I mean, obviously, I think we've all probably come across people who've provided expert opinions where they see themselves, because they've been asked to provide an expert opinion, feel it's their role to pick holes in everything they possibly can. And I don't think that's appropriate either, is it?
Oh, so true. No, you know, it's like the expert comes along and says, I've got to find something here because it's like the lawyer who's got to stand up and ask questions. It's like, you don't have to find something here. It's absolutely fine. And secondly, in court, when you're cross-examined, you can change your mind. You can be things that alter your opinion, quite different factual situations, a different way of looking at it. And so if you come across too dogmatic as well, as an expert, especially as an expert, because you're meant to be bipartisan, then again you undermine your credibility. You're not there to get an outcome. You're there to advise the court independently. That's the way you should consider it. So I think all those things are really worth considering.
Lucy, you've sat in plenty of hearings. How would you explain the environment as a clinician?
I think as a clinician, it feels very foreign and very threatening. I always think, we always tell members, look, you're not the person on trial a lot of the time, but often it feels like you're the person on trial when you're standing up in front of all those people and everyone's looking at you. I think it's a really uncomfortable situation for a lot of clinicians. There's often a concern about whether the media are there, and what's going to be reported about what you've said. So I think on the whole, most doctors would really do anything they can to avoid appearing in court. I don't think it's anything, we often get phone calls with, do I have to go? Can I say no? I don't feel comfortable. I don't feel it's my environment. And I think it's because it isn't a comfortable environment for most doctors.
One of the other things I've noticed is how slow it is.
Mm.
They're forever having a break. It's like you've spent a few minutes asking questions and then it's time for morning tea, let's all stand up. And it's slow and often, to be honest, I think boring for that reason, because often the only thing we know of court is what we've seen on American TV, which clearly isn't appropriate. It's not accurate, but that's what we have in mind. So I think people can find it quite a surprise when they're in there if they don't realise just how slow and often laborious it can be.
And I do think it's worth talking to the lawyers to say, look, I've got outpatient clinics with these huge waiting lists. I'm going to have to cancel my clinic to come to this. Can you try and fix the timetable so that I'm the first of the day, or that I don't sit around all day? Because I think a lot of the lawyers will be happy to take that into account if they understand the implications of what it means for your day-to-day job.
Absolutely. I think that's common now, is that if you've got very good reasons why they'll try and schedule it as best they can. But you're right, Sam, it's quite laborious and it does drag on.
Coming back to that tribunal environment, which, you're absolutely right, it is very intimidating. I think it's important also for the experts to understand that they will be challenged. They've usually been called by the prosecution, as it were, MPS, when we're representing a member, will certainly try and challenge everything that we possibly can in the expert opinion. But leading on from that, what if an expert approaches MPS and says, I've been asked to write an expert opinion, can you have a look at it for me to make sure that it's okay? Do we do that?
I could rewrite your expert opinion. I'm sure I have one.
I haven't ever come across that, and I'm not sure that it would be right to do that.
No, they do ask, but we don't. We can't. I mean, it's their opinion. And yeah. So can you just tell me, Sean, when you're cross-examining, because I would hope that the lawyer who's invited you to speak on, provide testimony on behalf of your patient is going to be nice to you in inverted commas. What happens? What's in the lawyer's thinking when you're cross-examining, and what are you trying to achieve when you're cross-examining?
Different lawyers have different approaches to cross-examination. Cross-examination is a difficult process because you don't have control of the witness. All right, so a good lawyer will try and ask questions that are what we call closed questions, so that that you're not going to give a person. If I'm cross-examining an expert, it's especially so because I don't want that expert to be able to reinforce the evidence that they've already given. And that will happen if I let them off the leash. So I have to ask very clear. I have to have a very clear understanding of where I'm coming from and what I'm trying to achieve, and I have to do that in a way that asks very closed questions. Hopefully, that I get yes or no answers out of, or I can refer them to documents and keep them corralled in what I'm trying to achieve. That's in a factual situation. I'm trying to undermine them, and sometimes some lawyers will be aggressive and try and upset. I think there's a thing called the magic triangle. What I tell a witness to in that situation is, if the lawyer is being aggressive, and some of them are, and some of them do it deliberately, that they don't address the lawyer. They listen to the lawyer and then they turn to the judge and speak to the judge, and it just breaks that eye contact, that thing, right? So, if it gets too much, your lawyer or the judge will intervene if it's overly aggressive. But it is an adversarial environment, and so a level of that kind of adversarial approach is obviously going to be allowed. I think that answers your question. Did I leave anything?
Yeah, no, that's fine. That's fine. Because I often wonder what it is, where those cross-examining lawyers want to go and what's actually in their thinking.
Correct.
Are they being really aggressive in their own thinking? And what you're saying is really they are.
Yes, they are. Yes, I think that, and a lot depends on the personality of the lawyer. I mean, there are lawyers who would do that as their stock and trade. They will always be an aggressive cross-examiner, whereas there are others who are more clinical and more. Okay, I've got a theme that I'm trying to understand, and you'll have 2 or 3 issues that you want to highlight in front of the judge, and you'll stay contained within those areas. Other aggressive ones will just keep asking questions to see where there's other stuff they can feed off.
Can you say no? Can the clinician say, look, I haven't got patient consent. I don't think this is relevant. I don't want to answer that question.
No. That's really up to the judge to decide.
So if you get asked a question about, the patient's sexual history, and you think it's nothing to do with this case, what do you say?
You could say that, but what if you had a competent lawyer? Their lawyer would be objecting to it on your behalf. All right. So, but you could also say, I feel uncomfortable answering that question. Your Honour, can I answer it because of X, Y, Z? You can yourself. And then there'll be a ruling. But if the judge thinks it's relevant and or disagrees with you, then you'll have to answer it.
And you never need patient consent for anything? No,
because it's within a court. Depending on the context, 98% of the time it's within a court. So it's one of the exclusions in the code that it's being done from. So you're fine in terms of that.
I think it's hard for doctors, though, when they're saying things that they feel are going to actually cause harm to not cause harm to their patient, but that are actually against their patient's interests. But yes. I think doctors can feel really uncomfortable giving those answers.
Correct, but they're bound to provide a factual response to it. What you're doing, therefore, is putting yourself as an advocate for and that's absolutely understandable, and not a criticism. An advocate for the patient, but really what you have to do is just answer the question as honestly and as appropriately as you can, because you're not in a while you're your patient and you're advocating for them in a health situation all the time. When you're in a court scenario, you're actually just a fact witness.
Yeah. I think that's a hard jump.
Who has to,
and especially when you're going to jump back into being in a therapeutic relationship
Correct.
with them next week.
Absolutely.
That's a hard situation.
But you'll get yourself into lots of trouble in the court situation if you adopt I'm just going to advocate and try and get a result here that's in the benefit of my patient, because you'll lead you down a road where either you're giving incorrect answers or you're opening yourself up to cross-examination by the other lawyer.
Yeah.
So just going back to being an expert witness, Sean, would it be fair to say that if someone's been asked to be an expert, they should just think of this a little bit like a game? This is the game that lawyers play, which is obviously very different to what we doctors do. And it's just normal for there to be perhaps a little uncomfortableness, if you like, when you're cross-examined and being asked various questions, and try not to take it personally, but just try and remain calm and professional, take it slow. And so it just helps them to manage that situation. Because it is, can you imagine having, a lawyer hammering at you for all day, which is what I've seen, and it must be incredibly uncomfortable. Would you say that's right? That you think of it as
I think that's actually a fair comment. I mean, I think the lawyers who is cross-examining, his role is to undermine you. I mean, his role is it is an adversarial situation where he is trying to undermine your evidence. That's his role, and therefore he's doing what he needs to do. My advice is never take it personally. Be open to listening. Sometimes changing a position occasionally in some ways is shows you're credible rather than undermines your credibility. But never let him bully you or let her bully you into changing your position just for the sake of it. But yeah, understand that that's what they're going to do. It isn't personal. Don't get over the top or descend into that pit of trading punches. Always stay above that. And you'll be fine. It really is. And if you're well prepared, if you're confident of your position, and you listen, you answer the questions directly, disagree when you have to disagree, it's entirely fine.
So, Sean, just to continue that, your role as a cross-examiner, you've already mentioned that one of the things you might do is to try and challenge the expertise of the expert, and point out, for example, that they've never done that particular operation. But the other area that it'd be interesting to expand on is where you're challenging the facts that are presented by the expert or the interpretation. And if you've got an expert yourself whose opinion is different from the opinion from the expert that you're cross-examining, how do you manage that situation?
Well, there's two things here, both with experts and factual witness, which I should actually point out. But with an expert witness, if you had an opposing expert opinion, then I would be putting that opposing expert opinion to that expert. I'd be probably saying, look, do you know Mr. Dr. Coxon? You appreciate he's an experienced person. He's done all these things. You'd get him to acknowledge the qualifications of the person that he opposed, and then you'd be saying, well, he obviously views it this way, and you'd be taking him through the differences, because I think you have to do that. You're sort of obliged to do that, and giving him the opportunity to explain that. Normally, in that situation, that probably has already been done by the person who's called him. So if I was calling an expert and the other party, whoever it was, had an opposing position, I would probably have been covering that off in opening. The second thing is when you're a factual witness, and if you're giving facts and the other party are giving opposing facts, the lawyer is under an obligation to put those to you. The lawyer must put the opposing facts to you for you to. There's a rule. I won't go into, but there's a rule that says the opposing party must put the contrary facts and to give the opportunity to comment on them. Sometimes that comes across as aggressive. I mean, when I do that, I say, look, I'm obliged by the court to put these. You realise that Dr. King has given evidence She says something different. I'm obliged to put these facts to you for your comment on. She says that you weren't there on the 22nd of January. You were there on the 23rd of January. What do you say to that? And I'm going to take you through those opposing facts because I have to. Now, a lot of witnesses will say it isn't. Don't worry about it. It's just an obligation that the court has. So you're always putting your contrary opinion or the contrary facts to the witness.
And coming back to the experts and the differences between them, I guess that really emphasises the importance of making sure that your expert opinion is an unbiased one, because the more biased it is and the less it takes into account perhaps of relevant facts, then the more vulnerable you are going to be as an expert to being challenged on that because of the difference between
Precisely, and in
opinions.
some courts, and I don't know whether it's happened in, it's an odd expression, but in some courts in factual assertion, they have what's called a hot tub, which is a hot tub of experts. Well, it sounds interesting, but basically what it is the experts get put in the box together and ask questions by parties and the judge. So they actually
get at the same time.
At the same time.
Oh my goodness!
So that and they it becomes more of a discourse than a actual from. So
do they have boxing gloves and everything?
No, that happens.
There's hot water.
I don't know who
who
came up with the hot tub expression, but that's what it's called, and it often works really well. So because your two experts, although they have on opposing sides, are meant to be acting independently and so that often happens. I haven't seen it done in a inquest context. I'm not sure. It could
Can I
well
just ask
be.
about the risk to doctors when they give evidence? I think it's a scary environment, and we all most of us really don't want to be there. And I think in the back of our heads, we're always thinking, if I do something wrong, am I going to be criminally liable for what I say? Am I going to be reported to the medical council? If it goes all badly wrong when you're giving evidence, what could be the consequences for a doctor?
Everything's privileged within a judicial or quasi-judicial context. So you can't be disciplinary. You can't. If you're telling the truth, the only thing that could ever happen is if you lied and you'd be guilty of perjury. But beyond that, nothing can happen. And that's why you should just relax.
So
and
professionally, I'm not going to be reported to the
council.
medical council if I give an opinion that's out of line with some of my colleagues.
None.
So I'm not going
as long as it's an honest opinion.
Right.
I'm thinking out loud at the moment because I've never come across it. If you were egregiously false in terms of your opinion, you went, and you could be shown to be, then there may well be some medical counsel. I have never come across it. I have to check it.
Right.
But it would have to be out on a limb where you are, where you're, you would be shown to be totally inappropriate or totally no justification for the position you're in. It's hard to imagine a situation, but it could arise where someone comes in with a vested interest or a conflict or something, and does that, and so there might be that kind of egregious conduct consequence. But generally speaking, that's probably such a small that we don't need to go into too much. Generally speaking, if you prepare properly, tell the truth, hold an honest opinion and provide it to them, there's no consequences for you.
Because there can be consequences for doctors if they give opinions in the media and the medical council have concerns about the professionalism. But actually you're saying if they say what they say in court,
totally
that's
different
actually
situation.
a different situation.
Yeah, it is, because media's in the public.
Right.
Thank you all for that really interesting discussion, and especially you, Sean, for demystifying the whole process for us in court. And thank you also to our listeners. I hope you found this useful. If you enjoy our podcasts, please subscribe and like them. If you have any suggestions for other podcasts or helpful feedback, please email us at nzpodcasts@medicalprotection.org.